Good afternoon, everyone, and welcome. I'm Walter Kilareski. I'm an Associate Professor of Civil Engineering here at Penn State University, and I'd like to welcome all of you to our seminar series this afternoon. This is the first seminar we're offering in this series. It's brought to you by the Mid-Atlantic University Transportation Center. This afternoon, our seminar leader is David Oliver. Mr. Oliver is the Deputy Assistant Chief Counsel for Motor Carrier and Safety at the Federal Highway Administration. He's a graduate of the Washington and Lee School of Law, Georgetown University School of Law, and the University of Virginia. The topic for this afternoon is tort liability in making safety work. A few details before we get started. Those of you at the other universities, if you have questions, please feel free to call in at any time. The numbers will be shown on the screen, and you can dial the phone number and give us a call. Mr. Oliver will take questions at any time during the seminar. For those of you that are in the audience here, I'd appreciate if you would write down the questions, pass those questions to me, and then I will get those questions to Mr. Oliver. So let me turn the seminar over to Mr. Oliver.
Thank you, Walter. Incidentally, Mr. Oliver's home in New Jersey. My name is Dave. If you have any questions, any of you out there or in here, I feel comfortable being called Dave, and I think you should feel comfortable calling me Dave. It's a pleasure to be here for a number of reasons. For the live audience here, I don't get the opportunity to speak to many about-to-be engineers. I unfortunately get you after the damage has been done and the mistakes have been made. So it's a particular pleasure to be able to share some of my experiences with you and hopefully give you some guidelines that you can carry with you, and regardless of what profession you choose or what you do later in life, in how to protect yourself against risk. For those of you at the other centers, it's a pleasure because this is a very novel experience for me. It's the first opportunity I've had to reach people in this manner, and I hope it works out in such a way that it continues on into the future. Tort liability. Tort is one of those interesting, very fascinating Anglo-Saxon words that when I entered law school, the first question you asked was, what is a tort? And no one ever successfully explained to us what a tort was. For your purposes, a tort is no more than negligence. That's all it means. There's nothing exotic about it. What we will try to do today is demythologize some of the concepts you might have about law, some of the mystique, and go behind some of the headlines that you see as to what's actually taking place in the legal profession, in the engineering profession, on the nation's highways, and hopefully give you some insight as to where we're heading in the 21st century. The first overhead that I've got up here on the screen has a statue of the Lady of Justice, and I put that up for a particular reason when I speak to engineers and engineering groups, because most of my engineering colleagues fancy themselves as closet lawyers, all think they can read law better, and are always asking for justice. They say, we want nothing more than justice. We're doing our job right and we get no justice. And I like to point out to them that justice is, in all senses, no more than a blind prostitute carrying a two-edged sword. So when you ask for justice, be very careful. I myself prefer mercy. I don't have one-liners. I'm never going to be Jay Leno's replacement, as Walter was auditioning for, but everyone talks about lawyers and lawyer jokes. And are they coming up? Are the overheads coming up on the screen? So we might as well dispense all the hilarity about lawyers and get it over with real quick. I'll give you a few seconds to look at it. And that's the general idea of what people have about lawyers and about tort law. I myself have a slightly different version, as Paul Newman portrayed lawyers in The Verdict, and I thought rather well. We are a dignified profession seeking mercy and proper recompense. Of course, in the presentation, what you should keep in mind in any liability action, as in any action in a court of law in which you have a jury, you are discussing your case with people. People from all walks of life, from all backgrounds, and all bring their own perceptions to a court of law. And I think this overhead illustrates very well. Some people, as with students in a classroom, might be thinking about spring training. Others are thinking about graduation. Some are actually listening to the lawyer's presentation of the facts at hand. One of the things that has distressed my engineering colleagues over the years are lawsuits. And they say, well, let's figure out some way to discourage all these frivolous lawsuits, because the only people that show up in court are those people who don't belong in court. There are certain tests that have been developed, one of which is to drop us all in this shark tank in advance to separate out the good cases and quality cases from the bad. That's not tort liability. It's not what tort liability is all about. Tort liability is all about is accidents, is damage, is hurt, is pain, is human people. It's about things that maybe we could have done better, maybe we should have done better, maybe we will do better. And that's the message that I'd like to leave you with today, to carry on wherever you go and whatever you do. Tort liability is about people. Accidents, for example, are a leading cause of death for children over 1 year of age, teenagers, and young adults. Every day, in every newspaper that you pick, you read of another fatality on the nation's highways involving these classes of people. Accidents are the leading cause of impairment: paraplegia, quadriplegia, epilepsy. I'd like to take a few minutes now and read for you some comments of people who were injured in automobile accidents to illustrate the sense of what I'm talking about. The real depths of human emotion. Bear with me, if you will. Some young quadriplegics have described themselves as trapped animals caught inside their own skin. Or the young lady who described herself as a prisoner locked inside a body that cannot make purposeful movement or express pain, apprehension, or fear. Or how about the words of one young woman who suffered terrible facial scars, who said, and I'm going to quote from a transcript, "Going to a supermarket can be devastating. People passing you in the aisles, each trying not to stare, turning their eyes away in shock or fear or pity. The checkout girl who must face you across the counter for what seems like an eternity. Going to a new doctor, having to disrobe, passing a group of playing children who have not learned to keep silent as their tactful elders do." Or how about a 21-year-old paraplegic who said, "I wish there was some place I could go, someone I could tell about how very much I want to run around in blue jeans this summer and be part of the crowd, to be normal, to do normal little things like splashing in the rain or riding my motorcycle and making guys stare and being real and a girl and alive instead of being half dead." No amount of money, none, can restore the feelings that these people have lost. That's what tort liability is about. It's not about the fact that possibly they had a little alcohol in their system when they took to the roads, or maybe they were excessive in their speed, 5 miles over the speed limit. It's about something that we could have done, that we in this room will have the opportunity to do, those of you out there have the opportunity to do, to prevent these feelings, to prevent these occurrences from happening. As engineers, you're used to the classical accident, a concrete, sudden physical effect. There's a chance, a definite place, and obvious damage. And that is really what you focus on. As a lawyer, an accident to me involves a myriad of effects. This is what we look at when we look at your standard tort liability case. Natural conditions, violation of traffic laws, unskilled driving techniques, were there subsequent accidents at the site of the accident, inadequate traffic controls, defects in the road structure, insufficient disaster prevention measures, inadequate road operations. It's a never-ending quest to find and apportion those things that we could improve on to make the highway system better. So what are we looking at these days? Well, there are national program areas. We're focusing on visibility, particularly illumination of signs at night. Design. Design has always been a very real problem for us. The courts have protected designers for many, many years because a design is a very personal to the implementer, very personal to the decision maker, very personal to governmental process. So we've been protected, and consequently we've got some bad designs out there, and we're perpetuating them. So design is becoming an area of high focus. The aging population, we're getting older. Older drivers in their late 60s, their 70s, their 80s have difficulties with reaction times. Their perceptions are different. Their sight distances are different. Truck-highway interfaces. Trucks are getting bigger. Cars are getting smaller. Elementary physics. We're going to have accidents, and they're going to be severe. And work zones. Work zones, for everything that we have done in the past 20 years to make work zones better, to improve the safety of work zones, to protect our workers, to protect the public, has not resulted in a savings of life or a reduction in accidents. We appear to be killing more people, and our work zones are becoming real danger zones. So they are a very high priority area today. Fatalities by first harmful event. Vehicle-to-vehicle collisions, the leading causes. Vehicle to objects, running into poles, running into barriers. Pedestrian encounters, and vehicle overturns, running off the road, drop-offs, potholes, whatever the cause. These are your 4 leading killers in automobile accidents. Collisions with roadside objects. We have a lot of trees and shrubbery, utility poles, guardrails. A tremendously difficult area. Try dealing with the National Park Service, and their mission is aesthetics, and telling them what a safe highway system is, and getting them to make safety changes, safety improvements, when they know that the aesthetics require trees right alongside the highways, require wooden barriers which will splinter on impact and kill people. Trees and shrubbery, big problem. Utility poles, we're taking them down, we're moving them. As fast as we take them down and move them, we still have accidents happening with people running into them. And guardrails. Guardrails not only have to be put in and put in correctly, they need to be constantly maintained. Work zones, which I like to call killing zones. As I said earlier, we have an increase in fatalities, particularly on interstate work zones. There's a tremendous amount of rehabilitation underway right now. A lot of nighttime work. Traffic conditions are bizarre. I was just telling Dr. Kilareski on the way into town today. I came in off of Business 322 and right up by the university. I don't know the exact street, but there's a work zone up there with a Jersey barrier on the right and barrels on the left-hand side. And I would be willing to bet that those barrels do not survive a Saturday night, let alone a rain situation. I think right here, right at Penn State University, you could go out and you could find a work zone condition which presents a hazard. What does tort liability do? And I'm going to repeat this over and over and over again so it's fixed in your mind. The purpose of a tort liability system, of any liability system, of a legal system, is to provide compensation to those who have been injured, is to prevent such occurrences from happening in the future, and is to provide public disclosure, both of governmental and private functions. 3 very basic, very simple principles. What happens in work zones? Well, you have construction problems, you have design problems, you have inadequate warning problems. And we'll talk about some cases later which will illustrate all of these things, but they're just the keynotes that we can extract out of them. If you're going to have an accident in a work zone, it's going to be with construction underway, it's going to be because of inadequate design, it's going to be because of improper warning. As engineers, you have to look at fact patterns just as we as lawyers do. You should have a basis in ethical and scientific integrity. If you know something is wrong, you've got to make the case to make it right. You should not just live with something that you know to be wrong because it's not just a job. It's a profession. You have to check for relevance, proximate cause. Proximate cause is the cause that leads to the accident. If your cones aren't set up right, if your signs aren't set up right, whatever it is that results in that accident, that's the proximate cause. You have to look at the role of standards. We're doing research. There's organization after organization that are setting standards. Standards are important. If you fail to pay attention to standards, you're going to wind up hurting people. Then there's a state of art versus custom. Every highway department that I know of has an engineer who knows how to do it because that department has been doing it for 50 years that way. Regardless of what the research has uncovered, regardless of what the state of the art uncovers. State of the art is very important and must be used. Custom is not preventing accidents. Relevant engineering principles, the things that you're learning here, hopefully that you'll carry on throughout your career. The role of experience and specialization. We need safety specialists. We need highway specialists. We need equipment specialists. Engineering as law is no longer just a generic profession or occupation. You've got to specialize. It has become that complex. Language skills, tremendously important. Not only in articulating your position if you're called into a court of law, but in documenting your case and documenting your work product, what you did. You've got to be able to present the facts in a cogent, articulate manner so that a jury, a judge, an expert witness will understand what it is that you've done on the project that you have designed, that you're working on. And you have to appreciate legal requirements. Never, never, never consciously violate a legal requirement for whatever reason. Countermeasures? Well, there are plenty of countermeasures. The federal government right now is emphasizing improved signing, marking, and delineating, work zone safety management practices, increased speed enforcement in work zones and high accident locations. Speed enforcement is critical. The latest studies that I've seen have shown that if you place a state policeman or a police officer 200 yards from a construction site, traffic will slow down to half its normal speed. No accidents. That's the latest research. Interaction with the enforcement community, vitally important. Relocate or eliminate utility poles. There should be nothing in the right-of-way of a highway that can injure someone or someone can run into. And identify and prioritize your high accident locations. You need to constantly look over your system. You have an on-site responsibility. There's a training responsibility for the contractor and the contractor's people. You need frequent inspections. You need proper installation and maintenance. Now, identification and prioritization of your list. You have to develop and maintain a list. Provide staff training. Notice that these things keep coming up, regardless of what the concept is, what we're talking about. You have to identify the problem. You have to train people. You have to coordinate with law enforcement and other transportation agencies. And, of course, we have specific funding needs to correct whatever it is that needs to be corrected. We do have short-term countermeasures. Active devices, variable message signs, activated speed warning signs, weather advisory signals, traffic activated signals. I come from the flashing lights and bells and whistle school myself. I love the system that the New Jersey Turnpike had years and years ago, where they had those activated signs that said fog ahead or accident ahead or construction ahead. Provides a tremendous amount of knowledge and information for the motorist. A motorist can then adjust his speed or his travel plans accordingly. Prevents many accidents. Remove unnecessary devices. How many times have you ridden the highway and come to a construction zone, for example, and had a 3-mile stretch with cones up and signs up, and there wasn't a soul around? Develop and maintain your performance inventory for all your devices, and implement priority schedules. What are we at the federal level doing? Well, we're encouraging the exchange of information. We're encouraging the establishment of multidisciplinary review teams, and we're encouraging the construction of accommodations for enforcement, in addition to providing a few bucks. Now what happens? What happens in a court of law? Well, tort liability spreads the risks. If we don't do the job, society's going to pay as a whole. It provides incentives for research, because if you're going to be spending all that money in tort liability, it's far better to find out what you can do to correct it in advance, and it avoids costly fact-finding, what could have been done. Is it a real problem that we're talking about? It's a very real problem that we're talking about. This I-95 accident that just happened down in Virginia, tremendously distressing. Over 20 years ago, when I first moved down to Virginia, I-495, the Capital Beltway, was undergoing reconstruction. And there were wooden barriers for miles. As far as the eye could see, there were wooden barriers everywhere. Every day on the way home from work, I could see 2 or 3, 4 people running into each other, or the barriers, or off the road. It was an optical illusion. It took a tort liability suit from the Center for Auto Safety to correct that deficiency, and probably brought about the, encouraged the use of the Jersey barricade that we use today, the concrete barricade. Today on I-95 in Virginia, a heavily traveled, probably the most heavily traveled corridor on the East Coast, under construction, and I know that the VDOT is under intense pressure to get this job done. The shoulder was taken, and the shoulder was made into another travel lane. 70-plus-year-old gentleman was in the on that part of what was a shoulder and was now a travel lane, had car trouble, assumed that he was on some type of shoulder thoroughfare or whatever, got out to check his car. Traffic had nowhere to go around him. A tractor trailer ran into him. The results? Fatality. It's just a quick schematic to show you what happened. The media gets involved very quickly. You've had a death. It's in the nation's capital. The first offense or the first defense is good offense. Okay, we've reviewed the lane policy. It appears to be correct in engineering terms. Change is unlikely. After further consideration and media pressure and public pressure, trucks barred from the shoulder of the I-95 stretch. Response to the fatal accident. A good response, a little too late. Let me discuss in detail some of the things, I'll give you an illustration of a case that wrap up some of the things we've just talked about. This case took place in the early 80s in Louisiana. $600,000 recovery was given by the court and upheld. The driver and the owner of a truck were involved in an accident at a construction site for pothole repair. It's an interesting case for two reasons. First, the driver of the truck was driving at approximately 62 miles an hour. The court held that while it was a violation of the law, it was not unreasonable under the circumstances, and you'll find that in many of these cases. I think from our own driving patterns we can see that although the speed limit is set up as the legal monitor and the legal example, on the interstate highways it's probably honored more in the breach than it is honored in the fact. So that 62 miles an hour was reasonable under the circumstances. There was evidence that the accident would have occurred had the driver been going 55 or maybe even 50. Second, the court also deemed as hearsay evidence information indicating that the driver was under the influence of amphetamines, was drowsy, and was driving erratically. Exactly the type of case that makes your blood boil. The truck was transporting livestock. It tipped over, killing or losing many of the cattle. The plaintiff, who was the fellow who recovered, who was injured, was driving an 18-wheeler, was on I-20, hauling 72,000 pounds gross weight. The trailer was double-tiered, cattle were loaded on both levels. As the vehicle approached the crest of a hill, it was trailing an automobile by approximately 60 feet, the auto switched into the left lane. A flagger at that point motioned to the truck to move into the left lane also. The truck veered sharply, struck the auto, which had slowed down, and precipitated the accident. Both the trial and the appellate court reviewed the duties of the traffic engineering department, which included the general duty to maintain a road in a safe condition so as not to expose the public to unreasonable danger, and the more specific duty to provide adequate safeguards or warnings. The central question in such cases of reasonable care involves a determination of sufficiency of warning. In this case, a 3-member maintenance crew was repairing potholes. The pothole in question was in the right-hand lane, 1,500 to 2,000 feet from the crest of the hill. The crew parked its dump truck on the shoulder directly across from the pothole and stationed one of the crew members approximately 50 feet behind as a flagger. The flagger was equipped with a small paddle that read slow on one side and stop on the other. The flagger, standing near the center line, flagged the tractor trailer into the left lane when it was only 100 feet from him. It was only another 50 feet to the pothole repair activity. The trial court found that the state's mode of operations was careless, substandard, and in violation of the common sense rules of liability. Moreover, the state's operations violated the department's own Maintenance of Traffic Control Handbook. The factors constituting negligence were the stationing of a flagger a scant 50 feet from the repairs, the flagger not waving the tractor trailer into the left lane until it was within 100 to 150 feet of him, the absence of state safety instructions or training for the flagger, failure to use signs, devices, warning signals, lights, or barriers, and the violation of the department's handbook. A road construction sign was present, a road construction sign, 400 feet east of the accident site, but it had nothing to do with this project. It did not impose a speed limit, did not signify a lane closure, did not specify the type of construction underway. The department's safety manual specifies that where the closure of an exterior lane of a multi-lane highway is necessary for fewer than 15 minutes, the following measures must be effectuated at a minimum. The work vehicle must be mounted with a flashing light, a warning sign, and 2 flags. And a spaced secondary vehicle, also equipped with a flashing light, warning sign, and 2 flags, must be stationed at least 150 feet behind the work site. Thus, liability actually rested on an adequate warning of the obstruction and presence of the emergency situation. That's a very typical type of case. You have a driver who was not driving 100% within the norms of what we would consider reasonable for a driver. Possible presence of amphetamines, possible careless driving. But the state was so deficient in its warning to drivers at this site, there was a massive recovery. What's going on today? Rail highway crossings, a very real problem. Many accidents. We need to install more warning devices. We need to close them. We need to provide separation structures. We need better education and enforcement. Why do I mention rail highway crossings now? It's an active problem. I use press reports to point out a lot of what is pertinent, what's happening out there in the field. Starting back in 1989 and coming right up to present. View of crossing obstructed in fatal Virginia train crash. Okay? Grade crossing. Grade crossing accidents. Biggest safety issue. 628 people killed last year in road rail crashes. Come right up to April 13th, 1992. Motorists at rail crossings nationwide still take that 5,000 to 1 chance, trying to run unobstructed or unguarded crossing sites. In this one particular case, a railroad engineer was so affected he went to the hospital with the fellow who was driving the truck that he struck, and he laid in the bed next to him because he just couldn't separate himself. And before the fellow died, all he did was he looked at the train engineer, and he looked at him and he said, "I thought I could beat you." Motorists race to beat trains at rail crossings creates carnage and perplexity. Is there something that we can be doing to stop this? Now, obviously, the preponderance of these accidents and the continuance of these accidents points out that people being people are going to try to beat these trains. We as highway engineers should be doing something to prevent that from happening. Just a quick graphic to give you an idea on your screens of what's happening today in terms of rail accidents. Tremendous problem. Hazard elimination. We have to use current data. We have to keep performing evaluations. We have to correct them. Hazards out there are every day another hazard is created. And every day another hazard is put on the shelf to stand behind the 10 hazards that we still haven't gotten to for whatever reason. What are we talking about? Hazards. We're talking about defective intersections, guardrails and median barriers, pavement and shoulder widening, pavement skid resistance, pavement markings. The very thing that I mentioned about up the street here in the center of town, right here at Penn State University. Hazards. We need improved signing and marking. We need to review and update by road class what we have on the system. We need to establish time and system-specific goals. We need to develop guidelines, high accident locations and poor operational performance locations. And we need special emphasis on sharp curves and nighttime delineation. Growing problem, nighttime delineation, illumination and reflectivity. Because of budgetary shortfalls or whatever, we haven't been checking our signs out there as we should be checking them. We're going to have more and more accidents happening at night because people are unable to see the signs. What are the most effective improvements? Traffic signs, illumination, guardrail improvements, obstacle removal, bridge guardrail transitions. These are the things that give you the most bang for the buck. If you've got to set up a system of priorities and you're removing your hazards, these are the effective things. Warning, removal, correction. How so? Let's talk about another case. Accident happened approximately 10:30 at night. Weather was clear and dry. A car was traveling on cruise control at 59 miles per hour. This particular car negotiated all curves on this road except the last, which was posted at 45 miles per hour. The driver disengaged cruise and he slowed. However, coming out of the curve, he reset cruise. At the same time, he noticed a 25 mile per hour speed advisory sign and a curve sign. He applied his brakes and he began slowing. He became momentarily inattentive. When he looked up, all of a sudden there was a sharp curve in front of him. He was unable to stop, went through the curve and struck a tree 13 feet away. The court found that the Department of Transportation had a legal duty to warn against an exceedingly dangerous curve, extending even to a driver who might be inadvertently inattentive. The degree of the curvature of this particular curve is 28 degrees. The current DOT standards prohibit construction of a curve with a degree exceeding 5.5 degrees. Although conceding that DOT is not under an obligation to bring an existing substandard road up to current design standards, there is a requirement that such roads be adequately signed. Why was the curve dangerous? It was dangerous because of the curvature and inadequate signing. At the time of the accident, there were no signs to delineate the location of the curve. In 1968, 20 years prior to this accident, there were numerous hazardous signs delineating this particular curve. They were located on the outside shoulder, they were fully reflective, and they could be seen bidirectionally. These signs were removed because 2 DOT employees determined that they were outdated and frequently knocked down. The employees did direct the installation of a flat arrow sign. However, there is no record of any follow-up to ascertain if the sign was installed. The sign was not in place at the time of the accident. A state trooper testified that he had investigated at least 6 or 7 accidents at this same location, and he had relayed his opinion to DOT that there was a problem with the curve, and he requested them to look into the situation. There were markings, a curve advisory sign, a speed plate located 416 feet from the curve, and no passing stripes. The court found that they might have been adequate for normally cautious drivers, but not for one who was momentarily inattentive. The department was found to be 50% negligent. The recovery was $1,700,000. Sounds like a lot of money. Sounds like a tremendous amount of money for a driver who was momentarily non-attentive. Well, let's look at the results and see what happened. The plaintiff had a craniectomy, a removal of a bone from the brain, and a removal of the tip of his left temporal lobe, 15% of his brain. He has an acrylic plate in his head. His right lung collapsed, and he underwent a thoracostomy and a tracheotomy. He was treated for gastrointestinal complications and partial paralysis of his left vocal cord. He developed tumors on his hands and his fingers, probably the result of taking phenobarbital since his lobectomy. His personality has changed from an easygoing to argumentative and temperamental person. He is also severely scarred and disfigured. Tort law. That's what we're talking about. Tort law equals fault, which equals negligence. Tort law is there to provide incentives to reduce accidents and a stimulus for careful conduct. Again, part of the demythologizing of the whole thing. Tort law is based on predictability, it's based on distributed risk, it's based on just compensation. We hold ourselves out to be a Judeo-Christian society. We hold ourselves out to be a moral society that's concerned about each and every person in that society's welfare. All tort law does is ensure that no person is left in a situation without recompense for the shortcomings of some other person. General sociology. One of the axioms of tort law we have that we are an increasingly affluential society. We have a concern for safety. Therefore, I ask you not to indulge in a hysterical reaction and decry tort law as being the evil. That is not the evil. The evil is defect, an omission, or an error of commission. New safety advances are underutilized because they may be construed as admission of past deficiencies. We find this day after day after day in our highway departments, and it is wrong. Tort liability is not at fault. I would ask you to ask yourselves, is fault important? How should we define liability? Should we limit damages? Is it too easy to sue? And before you answer that question to yourself, I would ask you to put yourself in the position of someone who has been aggrieved through no fault of his own. I ask you, those of you who have children, those of you who will have children, who have mothers, who have fathers, who have sisters or brothers, if one of those close people were injured in an automobile at a highway site, and were injured as a result of something that you, because of your professional, forget general knowledge, but your professional knowledge knew was wrong, would you say to yourself, well, government is a good government, and so we shouldn't do anything about it, or I know the people who did that job were good people, and so we shouldn't do anything about it, or would you go get a lawyer and say, I now have a permanently handicapped close person, help me find recompense. Help me find a way to make this right. And that's a rhetorical question that you should ask yourself in going through that four-step process, and then you come to the conclusion. And what do you look at? What are the different factors involved in determining what a safe level is, or levels of safety? Well, the road law. Look at the law first. Traffic volumes, level of traffic control, level of disaster prevention operations. All these things are important in whatever you do. In any tort case, the plaintiff tries to prove, that he should be compensated for damages. The defendant tries to prove that he's not responsible for the damages. The judge or a jury makes a decision. Law doesn't only involve going to court. There are many things involved. Private negotiations, settlements, insurance companies will settle out many of these cases. Legal actions are one. The employer through workman's compensation may be involved. An assailant driver, if there's another driver involved, the driver may be subject to criminal prosecution. The police are involved. Road administrators are involved. So it's just not a situation of this is an engineer and an engineer's road. There are many, many factors and many people involved in any highway operation that we do today. Your responsibility as road administrators, what will be your responsibility? To prevent defects or flaws which result in damages. And now my pitch. Law, what law is? Law is crystallized ideology. It's nothing more than the common sense of the day with all its prejudices and contradictions and half-baked economic theories caught forever in the amber of legal form. That's poetic. That's my, that's my pitch for the legal profession. We like a little poetry now and then, too. So let's recap. What's a tort? A tort is a civil wrong which results in injury or damages. No more, no less. What we are talking about, hopefully, are unintentional torts. Unintentional torts are those which are subject to or governed by the negligence rule. They're torts which appear as a result of negligence, not as a matter of will or malice. And I'd like to assure you right here and now that everything you hear about personal liability, about I may be personally liable, I may risk my house, I may risk my whole future, is not, in these cases, is not the situation. Before personal liability will devolve upon your heads, willful misconduct must be shown. So as long as you are proceeding within the course of your employment and doing your job as good employees, you do not have to worry about personal liability. This is a red herring, to use a slang term, that is not something that you should carry with you for your career or you should make any career decisions on. Your employer, your agency, will be responsible. The type of torts that we are talking about are unintentional torts, hopefully. Risk. We talk about risk management at the same time that we talk about tort liability. The two go together. Risk is endemic. It's everywhere. In everything you do every day of your life, from the moment you're born until the moment you die, there's risk involved. It can be reduced. It can never be eliminated. And that's what we are about. We are about the reduction of risk. Now, why is case law important? Case law is important to us because it sets forth pragmatic rules, it gives us interpretation, it sets forth facts, and it establishes precedent. It allows us to go to a body of doctrine to find errors that may have happened in the past and leads us to some insights on how to correct them. And in any liability suit, any suit, regardless of how responsible the plaintiff party is, these 4 tests must be met. It must be shown that there is a duty, that you as a road administrator or a construction engineer or a contractor or whatever have a duty to the traveling public. And ladies and gentlemen, I can assure you that that duty has been well established. You do have a duty. That test must be met. It must be shown that that duty was breached. The breach is something has happened to result in the accident, to result in damage. That something must be shown to be the proximate cause. That's a legal term. It means nothing more than but for the behavior on the part of the government, the accident would never have happened. Proximate cause. There's a linkage between what it is you did by commission or omission and the injury, and an injury must have taken place. If those 4 tests are not satisfied, there will be no liability recovery. So every time you hear about these horror stories and you hear about the poor aggrieved engineering profession and how it is that the lawyers are all in your pockets, it is not so. It is a pretty strenuous test that must be met. So what is your duty? To maintain the highway system reasonably in accord with the accepted engineering standards. Accepted engineering standards. Federal highway standards, MUTCD standards, whatever the professional ITE standards are. Again, reasonable care is accepted standards. Guidelines, reasonability means anticipation and efficient inspection. Does not mean that the highway system has to be in perfect condition to the limits of your ingenuity. The critical analysis that you have to use in any highway project is foreseeable injury and unreasonable risk. And that depends on the condition, the location, the circumstances. Let me quickly read another short case just to give you an idea of what I'm talking about here. $175,000 recovery. A skidding accident resulted from preferential icing on an interstate bridge. A sign was in place which read, "Watch for ice on bridge." The appellate court said the sign was improper and inadequate. How can one watch for ice that cannot be seen? What then is required? Well, the court said an illuminated sign during hours of preferential icing. The trial judge said, the sign language, "Watch for ice on bridge," hardly can be said to be meaningful when it does not give instructions to motorists as to the action or precaution to be taken if there is ice on the bridge. Its visibility in the dark and its noticeability by motorists are highly negative factors. In view of the expert testimony, that tests indicate that motorists see a sign less than 50% of the time. Lastly, the message, "Watch for ice on bridge," seems to be incongruous advice in view of the testimony that when ice is present on the bridge deck surface, it cannot be seen. This is the type of thing that we're dealing with. How many bridges have you crossed in the past week and seen "Watch for ice on bridge" signs? What does it mean? Your obligation? Monitor your facilities. What's going to happen if you don't? Well, the plaintiff's counsel is going to try to show that there was a duty. He's going to show a breach. He's going to show an alternate design. It's amazing. In every one of these cases, there's always an alternate design. More headlines. 1990, Seattle. State overruled bridge experts. DOT's own engineers were worried. Bridge. Headline. This is a very risky way to start a design project, the memo warned. How many different ways can we violate the very things that we've gone over? Will there be an alternate design? I can assure you, ladies and gentlemen, there will always be an alternate design. This is another one of the lawyers' pitches, since all my engineering friends are concerned about lawyers getting in their pockets. It does not take very much effort to find a colleague in the engineering profession who will come forth in a legal case and tell the judge and the jury that your design was deficient. Get to know each other real well, gentlemen, because somewhere in your career you may be appearing against one another. Engineers playing an increasing role in liability lawsuits. You don't only have to get to know your colleagues over in the legal school, get to know each other. Expert witnesses, concerns raised over booming business and testimony. That's all I'm going to say about that subject. So what can you do? Well, you design a project that has to be feasible, reasonably priced, and maintain its purpose. The key point, the agency, and that means you, can never assume the results. How do you prevent these things from happening? You have and follow a written policy, make status reports, prepare documentation, have adequate controls. What do I mean by that? Take documentation out of the 19th century, bring it into the 21st. Documentation must be uniform, universal, accurate, and automated. How do you do it? You take inventory, you have inspection, you have review. Why is it critical? Documentation is critical because it shows your performance, it helps the lawyer in disproving a claim, and it preserves your memory. Priorities, ranking system, and budgetary constraints. You have to prioritize what it is in light of the money you have to go out there and make your corrections. And you have to utilize all your inputs. Field forces, citizens, media. Just reading the newspaper, it's amazing how much I find. One of the most recent, I don't know if you've paid any attention to it, the pileup on I-5 in California in the fog zone. There were a series of newspaper reports on that they were monitoring the state police bands of communication. The state police were aware that this was a fog zone. They were aware it probably should have been shut down. Just quick illustration. Just use the media. And again, the final word is that if you have negligence, you're going to have loss regardless of your documentation. Do we have any questions? Okay.
Yes, that's why I'm coming up.
Okay.
We're getting down to the end of our seminar, and we wanted to provide some time for questions from the other universities. So if you're at another university and you'd like to have a question answered by Dave, please feel free to call in. We will take care of those questions. I have some questions from our audience here at Penn State, and I thought I'd pass those on to you, Dave. The first one was, and I think you've alluded to this a little bit, is to clarify maybe with some example the term proximate cause of an accident versus the actual cause. Vehicle speed, driver error, and versus something else.
The proximate cause would always be the actual cause. Again, as I said before, it's a legal term. If your error of omission or commission, if the sign missing at a construction zone were the causative factor of the accident, that is the proximate cause. Now when I say that is actual cause. If you say actual cause, well, actual cause would be the driver was speeding, the court would say, no, that's just a partial cause. The speed of the driver may have been an effective determinant in this accident, but it was actually the sign that was missing that was the cause. And that's why I don't differentiate between proximate cause and actual cause. It's not a physical distinction, it's a legal distinction. I hope I've made that clear for the person who asked the question.
Okay. Another question about the term clear zone and removing objects from that clear zone. You suggested that we remove trees and utility poles and other objects back of the clear zone. Yet our highway system that's in place, there are just literally thousands of trees and utility poles that are existing. It seems that somebody will run into one of these and then they will bring that up and make a case out of it. If you can comment to kind of the dilemma for the engineer of when to remove a pole or a tree and when not to. When can we accept trees in the clear zone?
Yes, when they don't cause accidents. You remove trees in clear zones unless they're 100-year-old oaks, because then you make everyone unhappy. I don't think there is any clear guideline as to when you take a tree down, but obviously if it's if it's very close to the highway and it's a high-speed thoroughfare, if it's a heavily traveled thoroughfare, you look at your traffic volume. If the traffic volume has been increasing, if it's a formerly rural area which has now become a suburban area on its way to an exurban area, that gives you a guideline that maybe you should do something about it before an accident happens. There is no hard and fast guideline to follow in the case of existing substandard highways. You know, there's a good argument that can be made that on an existing substandard highway, depending on the budget that you have, the correction can be made at some time, or that there are other more pressing corrections that must be made. That's a measure where you have to use your best professional judgment, and that's where professional judgment is important. That's where you look to the experience in the department, where you call on everything you have, not only book learning, but you have to know your community, you have to know your people using the thoroughfare.
Another question deals with how does risk management differ from traditional highway safety programming processes?
That's a tough one because traditional management safety processes have not been effective. I feel that risk management elevates highway management to a priority level. It calls attention to the need to incorporate safety in all planning and is the only way to go. So anyone that says to me, well, I'm a traditionalist in terms of highway safety management, you are a walking tort liability exposure candidate.
The last question I have from Penn State, what are the most effective steps that management can take to ingrain risk management into the agency culture?
I think you have to continually appraise management of the highway system needs, of the highway system deficiencies, and of the critical concern that the employee workforce has for such very obvious deficiencies. When you ask about inculcating anything into or mainlining anything into management processes, that means educating management, which is a tremendously difficult task. And if I had the answer to that, I would be with Dale Carnegie, out making millions instead of here.
Well, with that, I'd like to thank Mr. Oliver for spending the afternoon with us with this seminar. I'd like to thank the University Centers for sponsoring this, and we're looking forward to having many more of these in the future. So with that, I'll say thank you and close this seminar.